Hello, good evening, and welcome to BYJU'S Exam Prep. Welcome to Target Prelims 2023. Today is Lecture 1 on Indian Polity. Today, tomorrow, Sunday, and Monday. In these 4 live sessions, let's discuss lots and lots of MCQs and topics relevant for the upcoming Prelims 2023. So let's get started, but first up, I urge you to press the like button and please keep the live chat professional, thorough. Please don't indulge in unnecessary chats. Otherwise, like previous years, we will have to end and close the live chat. Let's get started and look at question number 1. In which of the following cases would a legislator stand disqualified In which of the following cases would a legislator stand automatically disqualified from the legislature if awarded a minimum sentence for committing the offense? Now let's go back to some of the basics. According to the Constitution, a legislator, whether belonging to Parliament or the state legislature, can be disqualified on various grounds. And what are these grounds? For example, for holding the office of profit. If there is a change in the nature of citizenship. For example, in order to contest elections, you have to be necessarily the citizen of India. What if once you are the citizen of India and you are elected to the legislature, after that you have renounced your citizenship, which means you will not continue as the legislator, you will stand disqualified. If you are adjudged insolvent, bankrupt for example, if you are subjected to or you are suffering from mental sickness, you are of an unsound mind. On all these grounds, the legislator can be disqualified. But who will disqualify? It is the president if you are the member of the parliament. It is the governor of a state if you are member of the state legislature. But the president and the governor shall disqualify you not on his own, but on the basis of the report of the Election Commission of India, and this report of the Election Commission of India is binding on the president or the governor. Now, what has happened in this case? For example, a recommendation. There was a complaint against the current Chief Minister of Jharkhand, Mr. Hemant Soren, that he is holding an office of profit and as such should be disqualified. A complaint was registered. The governor of the state referred this matter to the Election Commission of India. And Election Commission of India later on gave its report. But what the governor of the state of Jharkhand did, he did something unprecedented, which has never happened in the history of independent India. What he did, he kept the report of the Election Commission of India pending. Neither acting on this report nor rejecting this report, basically not acting on this report at all. But what has also happened is the former MP from Wayanad constituency, Lok Sabha constituency, the former president of the Congress party, Shri Rahul Gandhi, was also disqualified. Disqualified why? Because he was sentenced to 2 years in jail for a criminal defamation complaint that was filed against him. That is why this topic becomes relevant for your exam. But for that, you need to know that there are some constitutional provisions on the basis of which the legislator can be disqualified. What are these constitutional provisions? If you're holding an office of profit, if you are of unsound mind, if you have been declared or adjudged insolvent, if there is a change in the nature of citizenship. But the Constitution further says that the legislator can also be disqualified based on the law passed by the Parliament. And for that, Parliament has enacted a law. And what is that law? Representation of the People Act 1951. According to this law, if a legislator, whether legislator belonging to Parliament or to the state legislature, if the legislator is convicted by a court of law and sentenced to 2 or more years in jail, then this legislator stands automatically disqualified. But for that, you need to know a little bit of history as well. There used to be Section 8, Clause 4 of the Representation of the People Act 1951, according to which, listen to me carefully, if I'm a legislator and I am convicted for a case for which the punishment is given 2 or more years, and please listen to me carefully, the exam may tell you punishment of less than 2 years or the punishment of 2 years. It should be 2 years or more, not less than 2 years. Now, if I am convicted by a court of law and sentenced to a jail term of more than 2 years, I was not immediately disqualified. Then what would happen? I was given a 3-month window. And within these 3 months, I had the option of approaching the higher court. For example, if the trial court has sentenced me to a jail term of 2 or more years, I will not be immediately disqualified. I will have 3 months to appeal before the High Court. And in these 3 months, I will not be disqualified. But what has also happened in this case is there was a landmark judgment of the Supreme Court, Lilly Thomas versus Union of India, 2013. According to this judgment, as soon as a legislator is convicted by a court of law and sentenced to 2 or more years in jail, this legislator shall be automatically disqualified. Something else happened. For example, Lakshadweep member of the parliament in Lok Sabha, Mr. Faisal, he was also convicted by a trial court and sentenced to 10 years in jail. And when he was sentenced to 10 years in jail, the Lok Sabha Secretariat issued a notification saying the seat, Lakshadweep seat, is vacant because the legislator has been automatically disqualified from the date of his conviction because he has been sentenced to 2 or more years in jail. Then Mr. Faisal approached the Kerala High Court, and Kerala High Court said, elections are expensive in this country. So even if you are disqualified, fresh elections are to be conducted. And if fresh elections are conducted, it is going to be a huge burden on the exchequer. And even if a new legislator is elected, this legislator would have a term of less than 15 months. That is why we are suspending your conviction. We are suspending your sentencing. You should be reinstated as the legislator, as the member of parliament from Lakshadweep Lok Sabha constituency. Which also means that even if you are disqualified and sentenced to 2 or more years in jail, you can still approach the higher court, and the High Court, if it suspends the conviction, if it suspends the sentencing, you can be reinstated as the member of the parliament. Mr. Rahul Gandhi has now approached the Gujarat High Court asking for the suspension of the sentence. And if that happens, then he can be reinstated as the member of the parliament from Wayanad constituency to Lok Sabha. But here the question is asking, in which of the following cases would a legislator stand automatically disqualified? Now, which are these instances where a legislator would be automatically disqualified? If you are convicted by a court of law and sentenced to 2 or more years in jail. But the question is asking you, if this legislator is awarded a minimum sentence, not the maximum sentence, minimum sentence. If defamation, if you are convicted for defamation, the punishment, the maximum punishment is up to 2 years. Which means if Rahul Gandhi was awarded a minimum sentence, it could have been 6 months as well. And if Mr. Rahul Gandhi was sentenced to 6 months in jail, he would not have been automatically disqualified. A legislator can be automatically disqualified if he is convicted or she is convicted in a court of law and sentenced to 2 or more years in jail. So statement 1 is incorrect because the minimum sentence for defamation can also be 6 months. Harboring persons hired for an unlawful assembly. If you are harboring some individuals, giving shelter to some individuals who are hired for creating ruckus in the society, violating the public order, creating an unlawful assembly, then the punishment, the minimum punishment in that case is 6 months. And even if a legislator is convicted for 6 months, he will not be automatically disqualified. Similarly, obstructing public servant in discharge of his public functions. We have witnessed another fraud in Bihar where a former member of the parliament was released. His sentence was commuted, remission was carried out, and ultimately he was released. So that is why there is this link. But even if there is a legislator who is convicted for obstructing public servant in discharge of his public functions, then the punishment is 3 months. It is not about killing a public servant. For that, the punishment is extreme. But it is if you're harboring, if you're obstructing public servant in discharge of his official functions. In that case, the punishment is 3 months. But if it is money laundering, the minimum punishment that can be awarded to a legislator if he or she is convicted for money laundering, minimum punishment is 3 years. And 3 years, you would know, is more than 2 years, which means if a legislator is convicted for money laundering, for which the minimum sentence is 3 years, then this legislator would stand automatically disqualified under the Representation of the People Act. So what is the correct answer? The correct answer is 4, only 4C is the right answer. Is that clear? Let's look at question number 2. In the following question, the assertion A and reason R have been put forward. Read both the statements carefully and choose the correct option. Assertion is the Secretary General of Rajya Sabha is always the returning officer of the presidential elections in India. The reason is the Secretary General of Rajya Sabha was the returning officer of the 2022 presidential elections. Now, who is this Secretary General? In Lok Sabha also, in Rajya Sabha also, we have Secretary General. And the Secretary General is having the same status as that of the Cabinet Secretary. That is an important statement relevant for your civil services examination. Cabinet Secretary is considered to be the topmost civil servant in India, an IAS officer. In Lok Sabha also, the Speaker of the Lok Sabha would appoint a Secretary General. In Rajya Sabha also, the chairperson of Rajya Sabha, who is the Vice President of India, would appoint a Secretary General. And this individual will have the same status as the Cabinet Secretary, who is the highest ranking public official in India. According to the rules, these Secretary Generals act as the returning officer for the presidential elections. 2022 presidential elections were conducted. And for the second time, we have a woman president as the head of the India's Republic. That is why the office of the president as well as the office of the vice president becomes very important for your examination. There was a lot of controversy as well. That is what makes this topic even more important for your upcoming prelims examination. But the rules say Secretary General of Lok Sabha and Rajya Sabha would act as the returning officer alternatively. Alternatively in the sense, if for this election, Secretary General of Rajya Sabha is the returning officer for President's election, in the next President's election, it would be the Secretary General of Lok Sabha who would be the returning officer. And who is this returning officer? Basically, he is in charge of holding this election and he returns the result. Who is elected as the next President of India? That is why he or she is called as the returning officer. For example, in Lok Sabha election, who is the returning officer? The returning officer is the collector, is the district magistrate. That individual is the returning officer. So the statement, the assertion, Secretary General of Rajya Sabha is always the returning officer of the presidential elections in India, this is incorrect. Why? Because alternatively, for the previous election, which happened in 2022, the Secretary General of Rajya Sabha was the returning officer for the president's election, which means in 2027, when the next president's election would be conducted, the Secretary General of Lok Sabha would be the returning officer. Similarly, in the Vice President's election, in 2022, the Secretary General of Lok Sabha was the returning officer for the Vice President's election. And in the next election, in 2027, it would be the returning officer would be the Secretary General of Rajya Sabha. So the Secretary General of Rajya Sabha was the returning officer of the 2022 presidential election. This statement is correct. But what is the correct option then? It is the statement of the assertion is false, but the reason is true, but the R is true. So D is the right answer. You can also interchange this and say the assertion is that the Secretary General of Rajya Sabha was the returning officer of the 2022 presidential elections. And for that, the reason is that the Secretary General of Rajya Sabha is always the returning officer of the presidential elections in India. And in that case, D is the right answer. Let's look at another question. Staying with the office of the president. The President of India is administered oath or affirmation by the Chief Justice of the Supreme Court. The text of the oath includes which of the following? We have Schedule 3 of the Constitution. And Schedule 3 talks about, for example, we have Schedule 1, which talks about the names of the 28 states and 8 union territories in India. Schedule 2, it talks about the salaries and emoluments of various constitutional functionaries. Schedule 3, it talks about oath and affirmation. For example, if I have to contest election, for that I have to subscribe to an oath before the returning officer. And that oath is mentioned in the Schedule 3 of the Constitution. The judge of the Supreme Court, the judge of the High Court, Comptroller and Auditor General of India, the Union Minister, the Minister of State, all these oath and affirmation for these constitutional functionaries is mentioned in Schedule 3 of the Constitution. But listen to me carefully. When it comes to oath and affirmation for the President as well as the Vice President, that is not mentioned in the Schedule 3 of the Constitution. That is mentioned in the text of the Constitution itself. For example, the oath for the President is mentioned under Article 60 of the Constitution. When it comes to the oath of the Vice President of India, it is mentioned under Article 69 of the Constitution. But you should also know what is the text of this oath. For example, for the oath of the Vice President of India, the Vice President takes an oath and says, I, Mr. X, I'm assuming the office of the Vice President of India. For that, I have to take an oath. And the oath is, I will faithfully discharge the duties of the office about which I am about to enter. So the only oath for the Vice President is that I will faithfully discharge the duties of the office about which I am about to enter. But when it comes to the President of India, what is the oath mentioned under Article 60? That I will faithfully execute the office of the President. Not just that, I will preserve, protect, and defend the Constitution and the law. And you might be confused about Statement 3, that I will devote to the service and well-being of the people of India. This is also included in the oath or the affirmation of the President of India. And the correct answer then becomes D, all of the above is the right answer. Clear? Let's look at another question. Which of the following statements is or are incorrect? MLAs of union territories participate in the presidential elections but play no role in her impeachment. And impeachment is the term that we use only and only for the President of India. Vice President is removed, CEC is removed, CAG is removed, Chief Justice is removed, judges of the Supreme Court and High Court are removed. But the term impeachment is used only and only for the President of India under Article 61 of the Constitution. And the President is elected in an indirect election. That means people do not directly vote to elect the President of India, but people also vote to elect the President of India, but indirectly through their representatives. And where are these representatives? These representatives are there in the Electoral College. Who all are part of the Electoral College to elect the President of India? Electoral College consists of elected members of both Lok Sabha as well as Rajya Sabha, elected members of the state legislative assemblies, not legislative councils, and also the elected MLAs of the 2 union territories where we have legislative assembly right now, which is Delhi and Puducherry. So the MLAs or the elected MLAs of the union territories, yes, they do participate in the election of the President of India, but when it comes to the impeachment, they play absolutely no role in the impeachment. Why? Because under Article 61 of the Constitution, the President can be impeached on the grounds of violation of the Constitution. And for that, there has to be voting in both houses of the Parliament, Lok Sabha as well as Rajya Sabha. And in this voting, both elected as well as nominated members of the parliament participate. So nominated members, they are not part of the electoral college to elect the President of India, but they participate to impeach the President of India. In the similar fashion, the members, elected MLAs of the union territories or the state assemblies, they have a role in the election of the President of India, but they have no role in the impeachment. So MLAs of union territories participate in the presidential elections but play no role in our impeachment. This statement is correct. To make any change in the manner of the President's election, a constitutional amendment under Article 368 is needed, which needs to be ratified by at least half of the states as well. Now listen to me carefully. Jammu and Kashmir, the MLAs of J&K, they did not participate in the 2022 presidential elections because there is no assembly. They also did not participate in the 2017 president's election because at that time the legislature was not functioning, it was dissolved. So it has happened twice that the MLAs of J&K did not participate in the election of the President of India. But what if tomorrow there are elections to Jammu and Kashmir Legislative Assembly? MLAs are elected. Will these MLAs automatically become part of the electoral college to elect the President of India? For that, there is no conclusive yes or no. We don't have a conclusive answer whether it is yes or no. Why? Because the Jammu and Kashmir Reorganization Act of 2019, it said all the provisions related to the Union Territory of Puducherry will apply to the Union Territory of Jammu and Kashmir as well. So by that logic, for example, the former Secretary General of Lok Sabha, Mr. PDT Achari, he said since the provisions related to Puducherry Assembly are applicable to the Assembly of the Union Territory of Jammu and Kashmir as well, which means their MLAs, once they're elected, they will also be part of the Electoral College to elect the President of India. But there are others who say, no, this cannot happen. Why? Because for this, we need a constitutional amendment. Why? Because Constitution says, if you make changes to some of the provisions of the Constitution, which are known as federal features, you not only need a special majority in both houses of the Parliament, but you also need a ratification by at least half of the state legislatures as well. That is how GST was implemented in this country. That is how the service tax was imposed. But the point is, in 1992, 70th Constitutional Amendment Act was passed. Listen to me carefully. 1992, 70th Constitutional Amendment Act was passed. And because of this Constitutional Amendment Act, the MLAs belonging to Delhi and Puducherry, they were made part of the Electoral College. And this amendment was first passed by special majority by both houses of the Indian Parliament. Then it was sent to all the states. And when half of the states ratified this constitutional amendment, then it was sent to the President for signature. And you would know that whenever a constitutional amendment bill is passed by both houses of the Parliament and sent to the President, President has no power whatsoever. The only option available with the President is the President shall give his or her assent to a Constitutional Amendment Act. And you would know that was done through 24th Constitutional Amendment Act 1971. Prior to 1971, the President could have used any of her veto powers when a constitutional amendment bill was presented to her. But after 24th Amendment 1971, whenever a constitutional amendment bill is passed by both houses of the Parliament and sent to the President, President has only one option, and that option is the President shall give her assent to a constitutional amendment bill. So when Delhi and Puducherry, when these MLAs belonging to the two union territories, when they were made part of the Electoral College to elect the President of India, that was done through a constitutional amendment which was ratified by more than half of the states as well. So that is why constitutional experts say if tomorrow J&K MLAs are also allowed, are also made eligible to participate in the election of the President of India, to be part of the Electoral College. For that, just like 70th Amendment, we need to have another constitutional amendment ratified by more than half of the states, not less than half of the state legislatures in India. But what you need to know is that to make any change in the manner of the President's election, a constitutional amendment under Article 368 is needed, which needs to be ratified by at least half of the states as well. Because you would know that whenever a change is to be made to some of the federal features of the Constitution, it requires ratification by at least half of the states as well. For example, when you want to change the structure or the jurisdiction of the Supreme Court and High Courts, for that you need a constitutional amendment, which is slightly difficult because you need the ratification of at least half of the states as well. That is why, if you would recall, in 2014, when NJAC was passed by both houses of the Parliament, before this bill was sent to the President, it was sent to all the state legislatures in India. And only when at least half of the state legislatures passed a resolution accepting this constitutional amendment, then this amendment bill was sent to the President for his signature. And you would also know, and you should also know, that this resolution, which is passed by the state legislatures approving a constitutional amendment, that resolution should be passed by simple majority. And what is simple majority? More than half of the members present and voting. Statement 3. President of India exercises the pardoning powers under Article 72 as per her discretion. This statement is incorrect. Why? And this is where current affairs plays a very important role, whether it is related to Article 72 when it comes to the pardoning powers of the President, or it comes to Article 161, which deals with the pardoning powers of the governor. And let me give you one statement, and please tell me if this statement is correct or not. The governor of a state has the power to pardon a death sentence. Please tell me, is this statement correct or incorrect? I'll repeat. The governor of a state has the power to pardon a death sentence. Is the statement correct or incorrect? Some are saying yes, some are saying no. But if you were following the newspapers regularly, you would have come across a misleading title of some newspaper articles which would say the governor, according to the Supreme Court, has the power to pardon a death sentence. But this statement is incorrect. The governor does not have the power to pardon a death sentence. The governor can commute a death sentence. But then what is the controversy? Listen to me carefully. For example, I am an individual. I have been accused of a crime. And now the matter went to the court. And now the court has given me a sentence, given me a punishment. And what is the punishment? Either the punishment is death. If I'm sentenced to death punishment, after that, can the governor commute a death sentence? Yes, the governor can commute a death sentence. But if the governor commutes a death sentence, after that, can the governor then remit the sentence? For example, if I was sentenced to death, the governor, I filed a mercy petition before the governor. Governor is acting on the advice of the cabinet, the state cabinet, and the state cabinet is advising the governor, please commute this death sentence. And now the death sentence is commuted to life imprisonment. And let's say the life imprisonment is 20 years. For example, now I have to serve 20 years in jail. Can now the governor remit my sentence? Saying instead of 20 years, you have already served 7 or 8 years. Now I'm going to set you free. I'm going to remit your sentence from 20 to 7 years on the advice of the state cabinet. Can it happen? Previously, it could not have happened. Why? Because according to Criminal Procedure Code, if I was sentenced to death sentence, after that, if it was commuted to life imprisonment, I cannot be released before completing minimum 14 years in jail. I have to necessarily serve 14 years in jail. After that, I can be sentenced, I can be set free, my sentence, my period can be remitted. Also, if I was convicted for this crime, for which death sentence is an option, That means I have committed murder, for example, for which death sentence is an option, but the death sentence was not given to me. Instead, life imprisonment was given to me. That means I was convicted for murder, for which I could have been given a death sentence, but death sentence was not awarded to me. Instead, life imprisonment was awarded. So if life imprisonment is awarded, let's say for 20 years, can I then file a mercy petition before the governor? The governor will act on the advice of the state cabinet and reduce this 20-year imprisonment to 5 years, to 6 years. Or if for that matter, I have served 10 years in jail, the governor can say, you have served 10 years in jail, you are set free. It could not have happened. Why? Because you have to necessarily serve 14 years in jail. After that, you could be set free. But now what the Supreme Court has said, the Supreme Court has said that the governor of a state, acting only on the advice of the state cabinet, can release a convict even without mandatorily serving 14 years in jail. That is why there is this misleading title in some of the newspaper articles saying governor can pardon a death sentence. No, that is incorrect. Governor cannot pardon a death sentence. Only the president can pardon a death sentence. But the governor can commute a death sentence. The governor can remit a sentence even without mandatorily serving 14 years in jail, provided you have been convicted for an offense for which death sentence is an option. But this is not the discretionary power of the president or the governor. President will have to act on the advice of the central government, which is the cabinet. And similarly, the governor will also have to act on the advice of the state cabinet. So statement 3 is incorrect. Statement 4, President of India appoints the Chief Minister of Delhi. Lots and lots of controversy surrounding the Honorable Chief Minister of Delhi, always in the news. But the fact is, this statement is correct. Delhi being a union territory, and union territory is directly under the control of the center. Who is the executive head of the center? President, which means president is also the executive head of all union territories as well. And president will appoint the chief minister of Delhi. Someone else will administer oath to the chief minister on the advice of the president. President will ask the lieutenant governor of Delhi to administer oath to the chief minister of Delhi. But that lieutenant governor is administering oath to the chief minister of Delhi on the basis of, on the recommendation of the president, on behalf of the president of India. So the president of India appoints the chief minister of Delhi, correct? But what is the question asking you? Which of the following statements are incorrect? Only 3D is the right answer. That is why, please read the questions carefully. First, look at the statements and also look at what is the question asking you to do. Is the question asking you to point out the correct or the incorrect answer? That is why when there are 3, 4, 5 statements given in the question, it is better that you mark these statements with either C or I. C for correct, I for incorrect, so that once you are done with reading the question and finalizing the response, you should not make any mistake as well. If you marked I and C, now the question is asking you which of the following statements are incorrect. 3D only is the right answer. Clear? Done. Let's look at question number 5. Which of the following statements is or are correct? The Vice President, and listen to me carefully, some of you may make mistake here. The Vice President of India can be removed on the grounds of the violation of the Constitution. Statement 2, the Vice President of India is elected by the 2 houses of the Parliament assembled at a joint meeting. And I told you, presidential election was conducted, Vice President's election was conducted, Vice President is in the news for lots of statements that he has made about the basic structure doctrine, about the National Judicial Appointments Commission, about suspending some of the members of the Rajya Sabha. He is in the news. He was also in the news previously because he was the governor of the state of West Bengal, wherein he was in continuous conflict with the elected chief minister, Mamata Banerjee. But be that as it may, Vice President's office becomes important for the examination. The Vice President of India, he has 2 roles to play according to the Constitution. Role number 1, he presides over the sessions of Rajya Sabha, just like the Speaker of Lok Sabha does. So what is the most important role of the Vice President? he presides over the sessions of the Rajya Sabha. He is the presiding officer of the Rajya Sabha. But is the Vice President member of Rajya Sabha? No. When he is not the member of the Rajya Sabha, then how can he preside over the sessions of Rajya Sabha? That is why we call him ex officio chairperson of Rajya Sabha. He is not a member of the Rajya Sabha, but by virtue of holding the office of the Vice President of India, this person, this individual, is also the chairperson of Rajya Sabha. That's role number one. And role number two, whenever there is a vacancy in the office of the President, who will act as the President of India? The Vice President of India. And when the Vice President is acting as the President of India, he will not act as the chairperson of Rajya Sabha. That means he cannot be the President of India, acting President of India, as well as the chairperson of the Rajya Sabha and presiding officer of the Rajya Sabha at the same time. Then in his absence, who will preside over Rajya Sabha? The deputy chairperson of Rajya Sabha. And the deputy chairperson of Rajya Sabha, he is also in the news for lots and lots of reasons, and we don't have to mention that. That would be a waste of time. Deputy chairperson of Rajya Sabha is elected by Rajya Sabha MPs, that too by simple majority. And the deputy chairperson can also be removed. And who can remove the deputy chairperson of Rajya Sabha? Rajya Sabha MPs, by passing a resolution by effective majority. But when it comes to the Vice President of India, Vice President is elected by an electoral college. Who are the members of this electoral college? Listen to me carefully. Members of Lok Sabha and Rajya Sabha. When it comes to the electoral college of the President of India, it consists of, as I've told you, elected members of Lok Sabha and Rajya Sabha, elected members of the state legislative assemblies, elected members of the legislative assemblies of Delhi and Puducherry. Only elected. But when it comes to the electoral college of the Vice President, electoral college consists of members of both Lok Sabha as well as Rajya Sabha, which means members would include nominated, members would include elected members as well. But now what's the point? This Vice President can also be removed from his office under Article 67 Clause B of the Constitution. But how? First, this process has to initiate in Rajya Sabha. This is what we say is the exclusive power of Rajya Sabha. And you would know that there are three exclusive powers of Rajya Sabha. Can you tell me which are the three exclusive powers of Rajya Sabha? Anyone? Yes, please. First is the removal of the Vice President, correct? Second is, under Article 249, if Rajya Sabha passes a resolution, this resolution should be passed by 2/3 of the members present and voting. If this resolution is passed, this resolution will empower the Parliament. That what Parliament can do? Parliament can legislate on the state list if it is in national interest. You would know there is distribution of powers between union list, state list and concurrent list. Normally the state legislature has the power to make a law to legislate on any item mentioned in the state list, for example, police, law and order, gambling, agriculture. But if Rajya Sabha under Article 249 passes a resolution by 2/3 of the members present and voting, it will empower the Parliament. That what Parliament you can do? You can now legislate on the state list if it is convenient, if it is in the interest or the national interest. That is the special power of Rajya Sabha. Without Rajya Sabha's resolution, Parliament cannot legislate on the state list. And third is Article 312, which talks about creation of an All India service. Now, can you tell me how many All India services do we have? One, two, 3, 24, 27. Yes, we have 3 All India services, IAS, IPS and Indian Forest Service. Not Indian Foreign Service. Indian Foreign Service is a central service. IFOS, Indian Forest Service, is another All India service. Another question. If, for example, tomorrow, All India Judicial Service is to be created. If tomorrow a new All India service is to be created, known as All India Judicial Service, does that require a constitutional amendment? Yes or no? Some say yes, some say no, some say yes, yes, yes. No. A constitutional amendment is not required. Why? Because 42nd Constitutional Amendment Act was passed in 1976, wherein Rajya Sabha had already given an approval to the Parliament under Article 312 that you can create a new All India service known as All India Judicial Service, which will have a post not less than a district judge. So if a new All India service is to be created, such as All India Judicial Service, for that Rajya Sabha's approval is not required, because Rajya Sabha has already given an approval in 1976 when 42nd Constitutional Amendment Act was passed. Apart from this, if any other All India service is to be created, for example, All India Service on Education, All India Service on Trade, whatever, All India Medical Service, for that Rajya Sabha's approval, Rajya Sabha's resolution under Article 312 is needed. But what were we discussing? We were discussing that this process for the removal of the Vice President of India, this process must first initiate in Rajya Sabha. Rajya Sabha will initiate the process to remove the Vice President of India. And in Rajya Sabha, the resolution should be passed by effective majority. And then this matter will go to Lok Sabha. And if Lok Sabha also passes a resolution, but this time by simple majority, then Vice President stands removed, not impeached, removed from his office. So the Vice President of India, under Article 67 Clause B, can be removed if a resolution is passed by Rajya Sabha by effective majority. This resolution should be supported by Lok Sabha by simple majority, and the Vice President is removed from his office. But what are the grounds on the basis of which the Vice President can be removed? No grounds are mentioned in the Constitution. The President of India can be impeached from his office on the grounds of violation of the Constitution. The judge of the Supreme Court and High Court can be removed from their offices on the grounds of proved misbehavior and incapacity. But what are the grounds on the basis of which the Vice President can be removed from his office? These grounds are not mentioned in the Constitution. But what is the statement telling you? The Vice President of India can be removed on the grounds of the violation of the Constitution. Can be. Yes. If it was according to the Constitution, the Vice President is removed on the grounds of violation of the Constitution, then that statement would be incorrect. But it is saying the Vice President can be removed on the grounds of violation of the Constitution. The Vice President can be removed on the grounds of corruption, can be removed on the grounds of misbehavior, can be removed on the grounds of corruption, can be removed on any ground. Just that the grounds are not mentioned in the Constitution. If the statement was according to Constitution, the Vice President is removed on the grounds of violation of the Constitution, then that statement would have been incorrect. But this statement is correct because the Vice President can be removed on the grounds of the violation of the Constitution. But at the same time, the Vice President of India is elected by the two houses of the Parliament assembled at a joint meeting. Incorrect. Select the correct option from below. A, only one is the right answer. Sir, what is this? Vice President is elected by the two houses of the Parliament assembled at the joint sitting. 11th Constitutional Amendment Act was passed. The year was 1961. Prior to this, Vice President was elected on the basis of the joint sitting of the two houses of the Indian Parliament. Both the houses of the Parliament would sit in a joint sitting and elect the Vice President of India. But this procedure was thought to be cumbersome, complicated, and ultimately it was removed. Now the Vice President is elected by an electoral college, separately by Lok Sabha and Rajya Sabha. So there is no such thing as joint sitting. It used to be till the 11th Constitutional Amendment Act of 1961. So what is the correct answer? A, only one is the right answer. Yes, it's a trap question. Hopefully you will not be trapped when it comes to the real examination. Let's look at question 6. All these departments and ministries have been in lots and lots of news. I won't cite why they were in the news because that would end up wasting the time. But just listen to me carefully. The Prime Minister is also in charge of which of the following ministries and departments? The Prime Minister is appointed by the President. And on the advice, or should we say only on the advice of the Prime Minister, other ministers are appointed. But the President only administers oath or affirmation, oath of office, oath of secrecy to the ministers. But this particular minister would be Home Minister, External Affairs Minister, Defense Minister, Minister for Railways. This is the prerogative of the Prime Minister. And Prime Minister assigns various portfolios, various ministries to different individuals. But the Prime Minister also takes charge of some of the departments and ministries. Mr. Amit Shah is the Home Minister, Mr. Rajnath Singh is the Defense Minister, Mr. Piyush Goyal is the Minister, Ms. Nirmala Sitharaman is the Minister, Ms. Smriti Irani is the Minister. But there will be some departments and ministries which Prime Minister would keep to himself. And which are these ministries and departments? Listen to me carefully. Ministry of Personnel, Public Grievances and Pensions, Department of Atomic Energy, Department of Space. Yes, D, all of the above is the right answer. But why this question has been asked? It is not necessary for the Prime Minister to keep these departments with him. He can assign these departments and ministries to some other minister as well, to a cabinet minister as well. That's his discretion, because assigning portfolios is the prerogative of the Prime Minister. But the convention says, convention, unwritten rule, something that we have been following for a long time since the enactment of the Constitution, since the start of the parliamentary democracy in India. And since then, we have seen that there is this convention where the Prime Minister keeps to himself or herself some of the portfolios, such as the Ministry of Personnel, Public Grievances and Pensions, Department of Atomic Energy, Department of Space. D is the right answer. Clear? Okay. Question number 7. Which of the following statements is or are correct? When the Prime Minister is in charge of a ministry or a department, a minister assisting him is designated as the Minister of State with independent charge. This has been in the news. That's why this question has been asked. Even if the Prime Minister is the Minister for example, Minister for Public Grievances, Pensions, Ministry of Personnel, there is still Mr. Jitendra Singh, who is the Minister of State, assisting the Prime Minister. But if there is a Minister of State, junior minister, who is not under a cabinet minister, we call such a minister as Minister of State with independent charge. Since Mr. Jitendra Singh is the Minister of State in charge of Ministry of Personnel, Public Grievances and Pensions, but he is not reporting to the cabinet minister. He is reporting directly to the Prime Minister. So he is in charge of this minister, independent of a cabinet minister. That is why we call him Minister of State with independent charge. So when the Prime Minister is in charge of a ministry or a department, a minister assisting him is designated as the Minister of State with independent charge. This statement is correct. President's rule in a state can only be revoked by the President on the advice of the Union cabinet. This is a tricky statement. Why? Because something has happened in the past. Let's read the statement again. President's rule in a state can only be revoked by the president on the advice of the Union Cabinet. When it comes to president's rule, under Article 356 of the Constitution, what does the Constitution say? Constitution says, if the president is satisfied, what will satisfy the president? On the basis of the report of the governor, or even otherwise. If in a state there is breakdown of constitutional machinery, and I don't have to explain that because that you would have covered in your static subject. The point is, president's rule can be imposed in a state if in that state there is breakdown of constitutional machinery. But how would we know that there is a breakdown of constitutional machinery? The president will get the report from the governor, or even otherwise, which means the report of the governor is not necessary. Even without the report of the governor, the president's rule can be imposed in that state. And then when the president's rule is imposed, the first casualty, the immediate casualty is chief minister and council of ministers are dismissed. That's the first casualty. Chief minister and council of ministers dismissed. But what will happen to the legislative assembly of that state? Legislative assembly is not dissolved. Legislative assembly is first kept under suspended animation. Suspended animation so that the governor can explore if from this existing legislature a new chief minister is possible. Only once all the options have been exhausted, then the governor will dissolve the legislative assembly. But the point is, if the president's rule is imposed in a state, the process is the governor's report is sent to the president. President would say, why are you giving this report to me? I don't have any other power. I don't have the real power. I'm a rubber stamp. The president would refer this matter to the Union Cabinet. Union Cabinet will debate, decide, and ultimately give an advice to the president. And this advice is binding on the president. If the cabinet says in the advice that you have to impose the president's rule, president has no other option but to impose the president's rule. Similarly, when it comes to the revocation of president's rule, if the Union Cabinet gives an advice to the president that you have to revoke president's rule, president has no other option but to revoke the president's rule. Which means the reading of the statement would say, yes, the statement is correct. President's rule in a state can only be revoked by the president on the advice of the Union Cabinet. But now comes current affairs part. In Maharashtra, no government was possible when the elections took place. And everything that happened in Maharashtra becomes important for your civil services examination. Why? Because there is a matter, a landmark matter before the Supreme Court. Now the Supreme Court, 5-judge bench of the Supreme Court has reserved a verdict on that matter. All the arguments have been completed. Now the final verdict is to be given by the Supreme Court. That will change the fate of the politics of this country. That's going to be the most important, or should we say one of the most important verdicts in the history of the Supreme Court of India. Something to do with the defection of some of the MLAs of the Shiv Sena party, where they deserted Mr. Uddhav Thackeray and approached the camp of Mr. Eknath Shinde. And now Mr. Shinde is the Chief Minister of Maharashtra. Whatever has happened when it comes to anti-defection law, whatever has happened when it comes to the Maharashtra politics becomes important for your upcoming exams. What happened in Maharashtra? No government was possible. When no government was possible, the governor, Mr. Koshari, he sent the matter to the president saying that there is breakdown of constitutional machinery. No government is possible. I'm advising president's rule. The president consulted the Union Cabinet. Union Cabinet says, okay, the advice is please promulgate. Please impose president's rule in Maharashtra. And president's rule was imposed. But then it continued for some time. And then there was a spectacular development. three political parties decided to come together, the Shiv Sena, the NCP and the Congress. And they decided to come together, form the government, and Mr. Uddhav Thackeray was proclaimed as the Chief Minister of the state of Maharashtra, nominated as the Chief Minister, so that tomorrow they will approach the governor and stake claim to form the government. But just before that could happen, early in the morning, 8 o'clock, Mr. Devendra Fadnavis was sworn in as the Chief Minister of Maharashtra. Mr. Ajit Pawar of the NCP was sworn in as the Deputy Chief Minister of Maharashtra. But the state was already in President's rule. President's rule can be revoked only on the advice of the cabinet. But in the midnight, the President's rule was revoked. Why? Because there is some special power given to the Prime Minister, and that is known as deviation from rules. What is this deviation from rule? The rule is the Union Cabinet will meet and advise the President to revoke President's rule. If you want to deviate from this rule, because in the midnight Union Cabinet meeting is not possible, you can't wake all these ministers and say, come to Delhi, let's sit together because we have to advise the President that you have to revoke the President's rule. Something urgency has happened. The Prime Minister is given the power that you can advise the President, deviate from the rules without consulting the cabinet. You can advise the President. The Prime Minister, without consulting the Union Cabinet, advised the President, please revoke the President's rule in the state of Maharashtra. It was revoked early in the morning, and then 8 o'clock, the new government was sworn in. And that is why when we say President's rule in a state can only be revoked by the President on the advice of the Union Cabinet may be incorrect. Why? Because on the advice of the Prime Minister also, because the Prime Minister has the power that you can deviate from the rules, and even without Union Cabinet recommendation, you can advise the President to revoke President's rule. Even that is possible. So the question is asking which of the following statements are correct? Only one. A is the right answer. Okay. Let's look at question number 8. Which of the following statements is or are correct? The oath of a Deputy Prime Minister, Deputy Chief Minister is explicitly mentioned in the 3rd schedule of the Constitution. 2. The resignation of the Prime Minister necessarily leads to a fresh general election. Oath or affirmation is mentioned in Schedule 3 of the Constitution. When it comes to the oath of the Minister, Minister of State, candidate contesting the election, CAG, when it comes to the oath for the judges of the Supreme Court or High Court, all these oath and affirmation are mentioned in Schedule 3 of the Constitution. But there is no specific oath when it comes to Deputy Prime Minister or Deputy Chief Minister. They take oath as a normal minister, as a cabinet minister. It's just that the designation becomes Deputy Prime Minister or Deputy Chief Minister. But explicitly for a Deputy Chief Minister or a Deputy Prime Minister, there is no oath mentioned in the 3rd schedule of the Constitution. This is incorrect. The resignation of the Prime Minister necessarily leads to a fresh general election. Mr. Yediyurappa, we follow parliamentary form of democracy. The same system at the center, the same system we follow in the states as well. Mr. Yediyurappa resigned. Did it lead to a fresh election in Karnataka? No. From the existing legislative assembly, from the existing MLAs belonging to the BJP, Mr. Bommai was chosen as the leader of the party and ultimately was sworn in as the Chief Minister. So when it comes to the resignation of the Prime Minister, it does not necessarily lead to a fresh election. But the resignation of the Prime Minister necessarily means resignation of the entire Council of Ministers. This is what we call collective responsibility. And what is this collective responsibility? Prime Minister and his Council of Ministers, or Chief Minister or his Council of Ministers, they swim and sink together. The death of a Prime Minister means the death of the Cabinet, death of the Council of Ministers. The resignation of the Prime Minister or the resignation of the Chief Minister means the resignation of the entire Council of Ministers. But it may not lead to a new election. It will lead to a new Council of Ministry. That means new chief minister will be appointed, new prime minister will be appointed. Then on the advice of the new prime minister, new council of ministers will have to be sworn in by the president. On the advice of the new chief minister, a new council of ministers will have to be sworn in. But if no new chief minister is possible after the resignation of the chief minister, or no new prime minister is possible after the resignation of the prime minister, then it will lead to fresh election. But the resignation of the prime minister necessarily leads to a fresh general election. This statement is incorrect. So which of the following statements are correct? D, none. Neither 1 nor 2 is the right answer. Very good. Let's look at question number 9. Which of the following statements regarding the Central Bureau of Investigation is or are correct? CBI, again, always in the news. The origin of CBI dates back to the Second World War. The period of Second World War between 1939 to 1945. There was an allegation of corruption, bribery, when it comes to the purchases for the Second World War. And ultimately a department was created with the task of investigating all the bribery and corruption allegations when it comes to the war purchases. And this department was kept under War and Supply Department. And the CBI, it derives its power from Delhi Special Police Establishment Act of 1946. And the task of the CBI is basically, it comes under administrative control of the Department of Personnel and Training. DOPT. Tomorrow, when you become the IAS officer, you will also come under the administrative control of DOPT. IPS officers come under the control or the administrative control of the Ministry of Home Affairs. IFOS officers comes under the administrative control of the Ministry of Environment and Forests and Climate Change. The administrative machinery controlling the CBI is the Department of Personnel and Training. But this CBI, when it conducts an investigation under the Prevention of Corruption Act of 1988, it comes under the supervision of CVC, the Central Vigilance Commission. Lokpal also has an important role to play in this matter. But the point is, both CVC as well as CBI, they were set up on the recommendations of the Santhanam Committee, which was set up on corruption in the 1960s. This CBI is headed by a director, and this director is appointed by the central government on the recommendations of a committee. This committee consists of the Prime Minister, the leader of opposition, where in Lok Sabha or Rajya Sabha? The leader of opposition in Lok Sabha. If we do not have a leader of opposition in Lok Sabha, then the leader of the single largest party in Lok Sabha. And the third member is the Chief Justice of India or a judge nominated by the Chief Justice of India. Recently, what has happened, there are lots and lots of states which have removed something known as general consent. What is this general consent? CBI conducts investigation of corruption, for example, when it comes to a central government employee, when it comes to employees of the union territories, when it comes to the employees of the railways. But what if these central government employees are posted in the states? Normally what the states do, they give general consent to the CBI, so that whenever a CBI officer is entering the state and investigating these offences, they have the same status as that of the local police. But if the state government withdraws this general consent, then every time the CBI wants to investigate, it has to seek the permission of the states. And there are various states, Meghalaya, Chhattisgarh, Rajasthan, Telangana, which have withdrawn this general consent. But Calcutta High Court said something important. Calcutta High Court said if there is a central government employee, for example in West Bengal, and he needs to be investigated for a corruption case, CBI can investigate this officer even if West Bengal has withdrawn the general consent. That becomes very important statement for your examination. So what are these two statements? When the CBI conducts an investigation under the Prevention of the Corruption Act, its superintendence is under the Central Vigilance Commission. This statement is correct. According to the Calcutta High Court, the CBI can investigate offences committed by a central government employee working in a state, even if the state has withdrawn a general consent. This is correct. What is the correct answer? C. Both 1 and 2 is the right answer. Let's look at question number 10. Consider the following statements. The mandate of the ED, Enforcement Directorate, again, always in the news. Mr. Eknath Shinde is the Chief Minister. Mr. Devendra Fadnavis is the Deputy Chief Minister, ED. So when these two gentlemen were sworn in, the opposition said this is ED Sarkar, the Sarkar of Enforcement Directorate. They said, yes, it is ED Sarkar, the Sarkar of Eknath Shinde and Devendra Fadnavis. That was just to add some humor, but humor aside, let's focus on the question. Consider the following statements. The mandate of the ED is to investigate economic crimes and violation of foreign exchange laws. It was, I guess, in 1956 that a department was created known as Enforcement Unit. And this department was kept under the Department of Economic Affairs, DEA, which is also responsible for the conduct of for the preparation of budget in India, union budget in India. In fact, this was once a question asked in your prelims examination as well. Which department is responsible for the preparation of the union budget? It is the Department of Economic Affairs, which comes under the Ministry of Finance. So in 1956, an enforcement unit was set up, which was placed under Department of Economic Affairs. But very next year, in 1957, this enforcement unit was renamed as ED, Enforcement Directorate, and it was placed under the Department of Revenue. And this Department of Revenue is under the Ministry of Finance. What is the job of the Enforcement Directorate? To investigate the allegations of economic offences, money laundering, for example, violation of FEMA, Foreign Exchange Management Act, violation of Prevention of Money Laundering Act of 2002. Now, what has also happened is that ED, Current Affairs, ED has also been given the responsibility that all the wrongdoings when it comes to cryptos, basically an economic offense, can be investigated into by the Enforcement Directorate. And this Enforcement Directorate is headed by a director. What may be asked is, who are part of the committee to appoint, to select the director of the Enforcement Directorate? The director is appointed by the center, clear, but on the recommendations of a committee. Who are the members of this committee? Number 1, CVC, Chief Vigilance Commissioner. Number 2, Secretary of the Department of Revenue. Secretary of the Department of Personnel and Training. Secretary of the Department of Home. These 4 are part of the committee to recommend names to the central government for the appointment of the director of the Enforcement Directorate. And this director of the Enforcement Directorate will have a tenure of not less than 2 years. This is where it becomes even more important. The tenure should be not less than 2 years. That means what should be the tenure? 2 years. If the tenure is 2 years, this tenure can be extended now because of the recent changes. That is why this topic becomes important for your exam. The tenure of the ED director, which should be not less than 2 years, can be extended as well. 1 year at a time. How many times? Once, twice, thrice. That means 3 extensions can be given, so that the total term becomes 5 years. And the same is true for a CBI director as well. Can be extended 1 year at a time for the maximum of 5 years since the appointment. Same is true for the director of the CBI as well. That is why there was a controversy. When the current director of the Enforcement Directorate, he was given another extension, then another extension. Matter went to the Supreme Court. Supreme Court said, don't give any further extension. The central government gave another extension. Matter is still before the court. So that is why this becomes important for the examination. But this extension can be provided only if you mention it in writing that it is in national interest. If the central government wants to extend the term, the tenure of the director of the Enforcement Directorate by a year, another year, another year, to a total of 5 years, then you have to mention it in writing that this extension is necessary in national interest. And that is how you can extend the term of the ED director or the director of the ED. What is the question? The mandate of the Enforcement Directorate is to investigate economic crimes and violation of the foreign exchange laws. Correct? The term of the ED director cannot be less than 2 years. Correct? The term of the ED director can be extended beyond 2 years, 1 year at a time, to a maximum of 5 years. Can be extended only in national interest. Correct? So what is the right answer? D. 1, 2, 3 is the right answer. Done? Very good. Let's look at question number 11. Consider the following statements regarding the Prevention of Money Laundering Act. It's a very, very important law for your Civil Services Prelims examination because it has been in the news for almost the entire year. This Prevention of Money Laundering Act was passed in 2002, but significant amendments to this law were made in 2019. And what is more important and curious is that these significant amendments to the PMLA were made via a money bill. What is a money bill? Let's throw some light on the money bill. A money bill under Article 110 of the Constitution. A money bill is a money bill. If you want a simple definition of what is a money bill, a bill is a money bill if it is designated as a money bill or is certified as a money bill by the Speaker of the Lok Sabha. But Constitution says under Article 110 that a bill is a money bill if it deals with only those money matters as are mentioned under Article 110. For example, imposition of tax, abolition of tax, alteration of tax, that bill is a money bill. For example, if you want to say, let's say withdrawal of money from Consolidated Fund of India, such a bill is a money bill because it deals with money matters. For example, expenditure charged on the Consolidated Fund of India. Something else which has happened recently, which I got reminded just now. There are salaries of important constitutional functionaries. For example, President. For example, the Speaker of the Lok Sabha, for example, the judges of the Supreme Court, for example, the CAG, for example, the UPSC chairperson. All these salaries are charged on the Consolidated Fund of India, which means they are not subject to the vote of the Parliament. You would know that, that is basic, that is static, that you would have already understood. But recently there was a judgment, Anup Baranwal judgment of the Honorable Supreme Court, where the Supreme Court said that now election commissioner will also be appointed by the president based on the recommendations of a committee. and this committee will be headed by the Prime Minister, will have the Chief Justice of India, will have the leader of the opposition in the Lok Sabha. In that case, it was also pointed out to the court that election commissioners and the Chief Election Commissioner, they are perhaps the only constitutional functionaries whose salary and allowances are not charged on the Consolidated Fund of India. And that violates their financial independence. Clear? But if tomorrow the salaries of Chief Election Commissioner and election commissioners is also charged on the Consolidated Fund of India, for that we need to pass a bill. And such a bill which says that the salary of the CEC and ECs will also be charged on the Consolidated Fund of India, such a bill also is a money bill. And this money bill can be introduced only in Lok Sabha on the recommendations of the President. Now listen to me, look at me carefully, listen to the flow. It's a money bill under Article 110. Can be introduced only in Lok Sabha, that too with the prior consent, permission of the President of India. In Lok Sabha, it should be passed by simple majority. What if this money bill is defeated in the Lok Sabha? It does not obtain and get the required simple majority. It amounts to the censure of Council of Ministers. The Council of Ministers is censured. They have to drop everything. They can't take any policy decision. They have to immediately seek the confidence of the Lok Sabha, which means the Prime Minister will have to introduce a confidence motion in Lok Sabha, because the defeat of the money bill would give us a sense that the Prime Minister has lost the confidence in Lok Sabha. Since we follow parliamentary democracy, and in parliamentary democracy, the Prime Minister and his Council of Ministers are responsible to or accountable to Lok Sabha. The moment they lose majority in Lok Sabha, they have no other option but to resign. But if this money bill is passed by Lok Sabha by simple majority, this money bill goes to the Rajya Sabha. Attached with is the certificate given by the Speaker. And this certificate given by the Speaker says that this bill which is coming your way, dear Rajya Sabha, this bill is a money bill, which means you will have an inferior role. Rajya Sabha cannot reject a money bill. Rajya Sabha cannot amend a money bill. Rajya Sabha will have to either pass a money bill, or it may send recommendations to the Lok Sabha, or it may not act on this money bill. If Rajya Sabha decides not to act on this money bill for 14 days, at the end of the 14-day period, it shall be deemed that this money bill has been passed by both houses of the Parliament, which means Rajya Sabha has a very inferior role to play when it comes to a money bill. And this PMLA, Prevention of Money Laundering Act, was significantly amended in 2019 through the route of money bill, which the critics argue was done primarily to bypass Rajya Sabha, because Rajya Sabha will have a very inferior role to play when it comes to a money bill. But be that as it may, combined effect of the 2002 law and 2019 amendments to PMLA. What is the combined impact? The combined impact is, number one, burden of proof is on the accused. For example, if I am accused of committing murder, the burden of proof is on the prosecution. The state has to prove conclusively, beyond any reasonable doubt, that I am responsible for this murder, I have committed this murder. The burden of proof is not on the accused, the burden of proof is on the prosecution. But in the PMLA law, just like UAPA, the burden of proof is on the accused. I have to prove that I have not indulged in money laundering. Number two, your assets can be confiscated even before trial. Your property can be seized even before the trial begins. Third, listen to me carefully. We talk about retrospective effect. What is the retrospective effect? If a law has been passed by the Parliament, a criminal law has been passed, you can't give this law a retrospective effect, because that would be violation of Article 20, Clause 1 of the Constitution. The criminal laws can only be given prospective effect, which means if the criminal law is passed today, we can say that this law will enter into force from 1st of May 2023 or from 1st of January 2024. We can't say that this is the criminal law which is passed today and it will enter into force from 1st January 2022 or 28th of April 2021. You can't give criminal law retrospective effect. But you can give, Parliament can give a retrospective effect to a civil law, but not to a criminal law. But in this Prevention of Money Laundering Act, it can also apply retrospectively. Retrospectively in the sense, if Money Laundering Act was passed, listen to me carefully, in 2002, but I have bought some property or I have laundered money in 2000 or in 1990, this law will be applicable to me as well. How? With the assumption that since you used that laundering, you used money laundering techniques to buy some property or to have some cash, and you are still in possession of that property, you are still in possession of that money. Since you are in possession of the money today because of the money laundering, that means this law will be applicable even today for the offenses you have committed before the enactment of this law. Long story short, criminal law is basically prospective. It cannot be retrospective. That means you can't give retrospective effect to a criminal law. But PMLA will apply to your property even before the enactment of this law, with the assumption, with the hope that this property which you bought through money laundering, you are even today in possession of this property. That is why this law will be applicable to you. And it's very difficult to get bail when it comes to PMLA. And over the past 17 years, close to 5,400 cases have been filed under the Prevention of Money Laundering Act, but it has resulted in only 23 or 24 convictions. So PMLA is a very important law relevant for your upcoming examinations. Let's look at the question. Consider the following statements regarding the Prevention of Money Laundering Act. The burden of proof is on the prosecution. Incorrect, because the burden of proof is on the accused. The accused property can be attached only after trial. Incorrect. Even before the trial. The Act allows investigation into an offense even if it was committed before the enactment of the law. Correct? With the logic that you are still in possession of that property which you bought through money laundering even before the enactment of this law. Which of the above statements is or are correct? C, only 3 is the right answer. Right? Very good. Question number 12. Consider the following statements. Lots and lots of private members' bills have been passed. Some talking about changing the preamble. Some for the population control. Some for uniform civil code. Lots and lots of private members' bills. What is a private member bill? A bill introduced by a government minister is a government bill. A bill introduced by a non-minister is a private member's bill. Clear? That you would know. In India, there have been only 14 private members' bills that have been passed as legislation. Statement 2, the last private members' bill passed was the Supreme Court Enlargement of Criminal Appellate Jurisdiction Bill 1968. A private member's bill cannot be introduced by a member of the ruling party in the Rajya Sabha, while a member of the ruling party can introduce such a bill in the Lok Sabha. Which of the above statements is or are incorrect? I'll give you 1 minute to answer this question. Please answer. In India, there have been only 14 private members' bills that have been passed as legislation. This statement is correct, so please know the number. The last private member's bill was passed, which is the Supreme Court Enlargement of Criminal Appellate Jurisdiction 1968. This statement is also correct. A private member bill can be introduced by the member of the ruling party, whether it is in Lok Sabha or Rajya Sabha. A bill which is introduced by a non-minister is a private member's bill. And this private member's bill can be introduced in Lok Sabha, can be introduced in Rajya Sabha as well. And there is no discrimination whether you are from ruling party or the opposition. In fact, some of the private members' bills recently have been introduced by the members of the ruling party, but who are not the ministers. So this statement is incorrect. The statement is asking, the question is asking, which of the above statements are incorrect? Only one statement is incorrect, which means A is the right answer. Question number 13. Consider the following statements regarding the Keshavananda Bharati case. Keshavananda Bharati judgment was delivered by the Supreme Court on 24th April 1973, the day Sachin Ramesh Tendulkar was born. He celebrated his 50th birthday recently on 24th of April, and on that day, it was the 50th anniversary of the landmark Keshavananda Bharati judgment, which was delivered by a wafer-thin majority, 7-6. The case, which was heard by 13 judges of the Supreme Court, was heard by these judges for more than 60 days, which is considered to be the longest running case in the history of independent India. This case, the judgment is in close to 703 pages. Long story short, in this case, the Supreme Court invented a doctrine known as the doctrine of the basic structure, saying yes, Parliament has the power to amend any provision of the Constitution without disturbing the basic structure. Supreme Court did not elaborate what is this basic structure. But in further judgments, one by one, the Supreme Court has come up with a big list of basic structure. And Parliament has the power to amend the Constitution using Article 368 without disturbing the basic structure. Parliamentary democracy is part of the basic structure. Rule of law is part of the basic structure. Right to life is part of the basic structure. Objectives mentioned in the preamble is part of the basic structure. Similarly, power of the amending powers of the Parliament is part of the basic structure. Judicial review is part of the basic structure. Independence of judiciary is part of the basic structure. Secularism is part of the basic structure. So on and so forth. But if it is the 50th anniversary of Keshavananda Bharati judgment, it becomes important for your examination. Similarly, in the subsequent classes, we will discuss Official Secrets Act as well. Because this Official Secrets Act was passed in 1923. Today it's 2023, 100th anniversary, the century of Official Secrets Act. These centuries, 50 Golden Jubilee, Diamond Jubilee, Silver Jubilee becomes important for your examination. Please answer this question. Consider the following statements regarding the Keshavananda Bharati case. The Supreme Court declared judicial review as part of the basic structure of the Constitution. The Supreme Court declared that fundamental rights are beyond the amending powers of the Parliament. The Supreme Court declared that all laws introduced in the 9th schedule of the Constitution after the judgment can be subject to judicial review. Which of the above statements is or are correct? A, B, C, D. I'll give you 1 minute to answer. Some are saying B. Only one statement. B is the majority here. The Supreme Court declared judicial review as part of the basic structure of the Constitution? No. In fact, judicial review as part of the basic structure was communicated by the court in Minerva Mills case in 1980. Also after the Keshavananda Bharati judgment in Raj Narayan case, when it comes to the which was related to the disqualification of the then Prime Minister Srimati Indira Gandhi. So judicial review as part of the basic structure was not declared by the Supreme Court in the Keshavananda Bharati case. So statement 1 is incorrect. The Supreme Court declared fundamental rights are beyond the amending powers of the Parliament. Incorrect. Supreme Court said you can even amend fundamental rights. Fundamental rights are beyond the amending powers of this Parliament. This was declared by the Supreme Court in another case, Golaknath case of 1967, which was heard by the 11 judges of the Supreme Court. But in Keshavananda Bharati case, the Supreme Court said you can even amend fundamental rights without disturbing the basic structure. The Supreme Court declared that all laws introduced in the 9th schedule of the Constitution after the judgment can be subject to judicial review. Incorrect. This was something which was declared by the court in Vaman Rao case and later on in IR Kolo versus State of Tamil Nadu. Not by the Supreme Court in Keshavananda Bharati case. So D, none of the statements are correct. So you have to be absolutely clear what did the Supreme Court rule in this case. Supreme Court said there is no unlimited power available with the Parliament to amend the Constitution. You can amend the Constitution without disturbing the basic structure. And Supreme Court said secularism is part of the basic structure. Parliamentary democracy is part of the basic structure. When it comes to judicial review, that was said by the court later. When it comes to the 9th schedule, that was said by the Supreme Court later. For example, 9th schedule, it was inserted or added to the Constitution by the first, because of the first Constitutional Amendment Act 1951. And according to this 9th schedule, any law placed in 9th schedule is immune from judicial review. There is no judicial review. But matter went to the court after the Keshavananda Bharati judgment. Because if Keshavananda Bharati judgment says there is something called basic structure, is judicial review part of the basic structure? Supreme Court said in Minerva Mills case 1980 that relationship between fundamental rights and directive principles is also part of the basic structure. Judicial review is also part of the basic structure. This was later on reiterated by the Supreme Court in another landmark case, Kyoto Holohan versus Zachilhu in 1992. Supreme Court said judicial review is part of the basic structure. Because in Kyoto Holohan case, the 10th schedule of the Constitution was challenged. And you would know that in 10th schedule, which we will discuss today, hopefully, in 10th schedule, who has the power to disqualify a legislator? Speaker. 10th schedule, which was inserted into the Constitution in 1985 because of the 52nd Constitutional Amendment Act, it said the decision of the Speaker is final and binding. Matter went to the court. The court said we have no issues with the 10th schedule of the Constitution. But you are saying 10th schedule, Speaker's decision is final and binding, which means you are depriving the judiciary of its power of judicial review. That's why this clause is unconstitutional. But then matter went in 1980, Vaman Rao case, in 2007 in IR Kolo case. What about 9th schedule of the Constitution? Because 9th schedule says any law placed in 9th schedule is immune from judicial review. But you have said that judicial review is part of the basic structure. So how can we reconcile Keshavananda Bharati judgment and 9th schedule? Supreme Court said all laws placed in 9th schedule before 24th April 1973, there won't be any judicial review. Because before this date, there was no concept of basic structure. All laws placed in 9th schedule after 24th April 1973, there can be judicial review. And this was said by the court in Vaman Rao. This was said by the court in the IR Kolo case. So which of the above statements is or are correct? D, none of the statements are correct is the right answer. Question number 14. Any person receiving foreign contribution more than rupees 10 lakh in a financial year. This was changed recently. So if you have old information, old knowledge, update it. Any person receiving foreign contribution more than 10 lakh in a financial year from relatives has to intimate the central government within 3 months of the receipt of the foreign contribution. The FCRA registration is valid for 5 years. Foreign contribution cannot be transferred to any other person unless such person is also registered to accept foreign contribution. Which of the given statement is correct? A, B, C, D. Shall I wait for your answer? Such a tough question. All the statements seem correct. Okay. Foreign Contribution Regulation Act. It was initially passed in 1976, initially first by means of an ordinance when the nation was in a state of emergency. Emergency was imposed in 1975. Indira Gandhi, Srimati Gandhi was then the Prime Minister. But there were some issues with this law, and this law was later on repealed. A new FCRA was passed in 2010. Significant amendments to FCRA were made in 2019. And FCRA has been in the news throughout the year. I don't have to cite instances when and where was FCRA in the news. That would end up wasting our time. But the point is FCRA is in the news. Under FCRA, basically foreign contribution there are some individuals who cannot receive foreign contribution. Who are these individuals? Editors, publishers, cartoonists of the newspapers, candidates contesting elections, political parties as well. Similarly, judges. All these individuals are prohibited from receiving foreign contribution. In 2019, another term was added, public servant. Now these public servants also cannot accept foreign contribution. That's number one. Number two, previously, for example, if there is an organization A and there is an organization B, both have FCRA license. And this license is valid for 5 years. That means if I am part of an organization A, a non-governmental organization, and we want to work for the downtrodden, marginalized, disadvantaged sections of the society, we want to give them health benefit, education, or whatever, we can apply to the Home Ministry, because Ministry of Home Affairs is responsible for this FCRA license, and we can apply for the FCRA license. And if I have the FCRA license, that means I can receive foreign donation, so that money I can use to run my non-governmental organization, NGOs. Previously, if A as well as B, both were eligible to receive foreign contribution because both of them have FCRA license. If A has received 10 crore as foreign contribution, it could have given a part of this 10 crore to organization B as well, because both of them are eligible to receive foreign contribution. A has received, B has not, but B is eligible to receive. So the money that A has received, a part of it can also be diverted, can also be transferred to B. But now it has been stopped. If A has received foreign contribution, B is also eligible to receive foreign contribution, but the money received by A cannot be transferred to B, even if B is eligible to receive foreign contribution. That's another change in 2019. Another change. Prior to 2019, A, this organization which has received foreign contribution, it could have spent up to 50% on administrative purposes. For example, I'm the owner of this non-governmental organization. I have some workers under me as well, employees under me as well. I have received foreign contribution. 50% of this contribution I could have spent on the rent, I could have spent on the employee benefits, I could have spent on travel, I could have spent on stationery, whatever it is. But now this 50% limit has been reduced to 20%. Only 20%, maximum of 20% of the foreign contribution you can spend on administrative purposes. Another change. Previously, if I am the owner of this organization, I have applied for FCRA license, which is valid for 5 years. I could have received this foreign contribution in any bank account which I have specified. I could have a bank account in Hyderabad, I could have a bank account in Chennai, I could have a bank account in Kolkata. But now the change in 2019 says, you can have this bank account. It should be from the State Bank of India. And this bank account should be where? Where the central government will specify. That means central government will specify the branch of the State Bank of India, and only in that branch you can receive foreign contribution. And that branch is on the Parliament Street, Sansad Marg, the State Bank of India branch. Which means even if I am the owner of an NGO or a university which is eligible for foreign contribution, even if I'm in Chennai or in other parts of Northeast, I have to necessarily open a bank account in New Delhi, in the State Bank of India, in the Parliament Street or Sansad Marg, and only in that bank account I can receive my foreign contribution. Many changes have been made. And if you want to renew your foreign FCRA license, there can be investigation by the central government as well. Are you the organization who is responsible for religious conversion? Are you the organization which is responsible for misappropriating this money? If yes, then we may not renew your FCRA license. And that is how lots and lots of organizations, their FCRA license could not be reviewed, could not be renewed. Clear? But the point is, for example, you are an individual. Listen to me carefully. You are receiving foreign contribution from your relatives outside. Previously it was that you could have received 1 lakh, and if you receive less than 1 lakh or up to 1 lakh, you don't have to approach the central government and inform or intimate the central government that I have received 1 lakh from my relatives from abroad. You don't have to. But if you receive more than 1 lakh, you had to intimate the central government that I received more than 1 lakh as foreign contribution from my relatives, and you were given 1 month, 30 days to intimate to the central government that I have received foreign contribution. Now this limit has been enhanced. And what is the enhanced? Listen to me carefully. Any person receiving foreign contribution of up to or less than 10 lakh, you don't have to intimate the central government. Here is an individual, you have received foreign contribution from your relative up to 10 lakh or less than 10 lakh, you don't have to intimate the central government. But if you have received this foreign contribution in a financial year more than 10 lakh, then you have to intimate the central government, and that too not within 1 month. Limit has been increased within 3 months. So any person receiving foreign contribution more than 10 lakh in a financial year from relatives has to intimate the central government within 3 months of the receipt of the foreign contribution. The statement is correct. The FCRA registration is valid for 5 years, correct? And you have to renew it. It can also be suspended. Your FCRA license can be suspended for 6 months. That is another important statement that you have to keep in mind. Foreign contribution cannot be transferred to any other person unless such person is also registered to accept foreign contribution. This is incorrect. It used to be a provision previously. As I said, one organization, another organization, both eligible to receive foreign contribution, you could have diverted some contribution. But now that's not the case. Which of the statements given above are correct? B, only 2 statements are correct. Great. Question number 15. Now this is slightly different way of putting a question, which has not been asked this way by UPSC in the past, but U in UPSC stands for unpredictability. So you have unpredictable service commission. Maybe this question can be asked. This way the question can be asked. Considering that you are a citizen of India and want to challenge the validity of the Places of Worship Act 1991 in the Supreme Court, which one of the following can be invoked as the grounds for such a challenge? Places of Worship Act was passed in 1991. What was the intention? If this is a religious structure and this is 15th of August 1947. 15th of August 1947, when India gained independence, when dominion status was given to India. whatever is the nature of the religious property cannot be changed. So a temple on 15th August 1947 cannot be later on converted to a mosque or vice versa. Not just that. If, for example, this is a mosque or this is a dargah belonging to the Shia community, Shia sect of Islam, later on it cannot be converted to the Sunni sect of Islam as well. Although the religion is same, but cannot be transferred, cannot be diverted, cannot be converted to the religious property of another sect as well. So basically, this law provides for the maintenance of the religious character of an institution. But there were some exceptions. For example, archaeological monuments, they were excluded from this law. Similarly, Ram Jannabhoomi and Ayodhya, they were also, this disputed structure was also excluded from this law. But there have been petitions in the Supreme Court challenging the validity of this law as well. On what grounds can you challenge this? Ground number one, violation of fundamental rights. Article 25 talks about fundamental right to profess, practice, and propagate your religion. I want to practice my religion. And for that, I claim that a particular temple right now, a particular mosque right now, used to be a temple in the past. If you're depriving me of my right, fundamental right to worship my temple, because of the Places of Worship Act 1991, on this ground, I can challenge it in the court. And that is why the challenge, there is a petition in the court challenging the validity of this law. We have seen some instances which happened in Krishna Janambhoomi case in Mathura. We've seen that happening in another place in Uttar Pradesh as well. So lots of controversy on this. But on the grounds of fundamental rights violation, you can challenge this law in the court. Not just that, violation on the grounds of the basic structure as well. What is basic structure? One part, judicial review. Judicial review is part of the basic structure. But this law says, what is the character of a religious institution? The character as it stood on 15th of August 1947 will remain the same. Cannot be altered, cannot be changed, and no case can be filed in the court, which means you are depriving or violating judicial review, which is part of the basic structure. You are depriving the courts of their power to review a particular law. So on the grounds of violating the basic structure, one such basic structure is judicial review, it can be challenged. On the grounds of arbitrariness, right to equality under Article 14. It also gives you another fundamental right, right against arbitrariness, without any logic. For example, what is the logic in having 15th August 1947 as the cutoff date? Why not before that? Why not after that? Why not 26th January 1950 when the Constitution was enacted? Clear? So on the grounds of arbitrariness, you can say that this date, 15th August 1947, has been arbitrarily, without any logic chosen. On all these grounds, you can challenge the validity of this law, which means D, all of the above, is the right answer. Very good. Question number 16. 104th Constitutional Amendment Act sees the reservation of seats for Anglo-Indians in Lok Sabha and the state legislative assemblies. If a sitting member of one house is also elected to the other house, his seat in the first house becomes vacant. Lots and lots of constitutional amendments have been in the news, but you should remember and keep note of some of the recent constitutional amendments. In match the following type questions, this can be relevant. Can you tell me what was 99th Constitutional Amendment Act all about? Anybody? And then 100th, 101, 102nd, 103rd, 104th, 105th, recent amendments. And all these amendments are in the news. 99th Amendment, which dealt with National Judicial Appointments Commission. Later on, it was struck down by the Supreme Court, known as the Fourth Judge's Case. Supreme Court said NJAC violates independence of judiciary. Independence of judiciary is also part of the basic structure. Not just independence of judiciary, it also violates primacy of Chief Justice of India in judicial appointments, which is also part of the basic structure. Vice President, Law Minister of Union, Law Minister, they have all criticized NJAC judgment, in fact criticized the basic structure doctrine of the court as well. But the point is, you may also be asked, 99th Constitutional Amendment Act was struck down by the Supreme Court by 4:1. There were 5 judges hearing this case. 4 judges said that NJAC is unconstitutional because, number one, it violates independence of judiciary, which is part of the basic structure. One more basic structure was added to this list, and the court said primacy of Chief Justice of India in judicial appointments is also part of the basic structure. Because right now what is happening, there is something known as the collegium system, which you would know. Let's say we have to appoint a judge to a Supreme Court. For that, Chief Justice of India will consult 4 senior judges of the Supreme Court. Let's say my name is to be recommended to the President for appointment as the judge of the Supreme Court. All these 4 senior most judges of the Supreme Court, they are in agreement with my name. Yes, this name should be sent to President for appointment. But Chief Justice of India says, no, I don't agree. My name cannot be sent to the President for appointment because Chief Justice of India enjoys a virtual veto when it comes to the judicial appointments. But in NJAC, if more than 2 members of NJAC would not agree with this name would not be sent. Which means NJAC consisted of Chief Justice of India, 2 senior judges of the Supreme Court, Union Law Minister, 2 eminent persons. Only if more than 2 of these members would object to my name, only then my name cannot be sent to the President for appointment. But if in NJAC, 2 senior judges of the Supreme Court, Law Minister, 2 eminent persons, they agree with my name, but the Chief Justice does not agree with my name, even then my name would be sent to the President for appointment. So in NJAC, the Chief Justice does not have primacy. The Chief Justice does not have the virtual veto. And Supreme Court invented another basic structure saying primacy of Chief Justice of India in judicial appointments is also part of the basic structure. And on these grounds, NJAC was declared unconstitutional. 100th was basically India, Bangladesh land boundary agreement. 101st was the introduction of the goods and services tax. 102nd led to the creation of National Commission of Backward Classes, because previously it used to be a statutory body, a body created by the law passed by the Parliament. But now NCBC was given a constitutional status. 103rd, 10% reservation for economically weaker sections of the society. 104th, extension of reservation, or should we call it extension of political reservation? That means reservation for SCs and STs in Lok Sabha, in legislative assemblies. But this 104th amendment did not extend the reservation for Anglo-Indians. So Anglo-Indian reservation ceased because of 104th amendment. 105th amendment gave power to states and union territories to have their own list of socially and educationally backward classes of citizens. Because when 102nd Constitutional Amendment Act was passed, because of this 102nd Constitutional Amendment Act, National Commission for Backward Classes as a constitutional body was created. Previously it was a statutory body. Then matter went to the Supreme Court. Supreme Court said, just like we have one list of SCs at the central level, one list of STs at the central level. In the same way, we will have one list only at the central level known as socially and educationally backward classes of citizens. Only the president will have the power, which means only the central government will have the power to add castes to this list and remove caste from this list. States and union territories cannot have their own list of socially and educationally backward classes of citizens. So basically, the states were deprived, the union territories were deprived to have their own list of socially and educationally backward classes of citizens. And then, because of this Supreme Court verdict, Parliament got together, amended the Constitution again, 105th Constitutional Amendment Act, and it basically gave the power to the states and UTs, gave this power to the states and UTs back, that now you can have your own list of socially and educationally backward classes of citizens. So all these important constitutional amendments you should keep a note of, because that is important for your examination. In fact, you can also talk about 97th Amendment. A portion of this was struck down by the court 2 years ago. The portion which talked about interstate cooperative societies. The Supreme Court said interstate cooperative societies, yes, Parliament can make a law, but when it comes to cooperative societies within the state, that power is only with the state legislatures. That power cannot be given to the center, cannot be given to the Parliament. In fact, when it comes to this question, 104th Constitutional Amendment Act seized the reservation of seats for Anglo-Indians in Lok Sabha and state legislative assemblies. It's correct, because there used to be 2 nominated Anglo-Indians in Lok Sabha, 1 nominated Anglo-Indian in state legislative assemblies. If a sitting member of one house is also elected to the other house, his seat in the first house becomes vacant. This statement is also correct. C, both 1 and 2 is the right answer. Okay. Now, if you have any questions, please let me know. I'll try and answer these questions. And then let's meet tomorrow, 7:30 in the evening, and we will discuss a whole list of important questions as well as important concepts relevant for your upcoming prelims examination. Any questions, please let me know. You can find this updated PPT, all this annotated PPT on our app. So you can download the BYJU'S Exam Prep app and you can find the annotated PPT there. Sir, could you explain collegium system? We'll discuss that tomorrow. FCRA is allowed to individuals, organizations, non-governmental organizations, those who are universities as well. Sir, is there a provision that member can choose which seat? If you are elected to both Lok Sabha as well as State Legislative Assembly, then you have the option to choose which of the seats you want to retain. But if you are a member of the Lok Sabha and now you are elected to Rajya Sabha, that means Parliament, your seat in the first house becomes vacant. Is money bill under judicial review? Initially, Article 110 said the certificate given by the Speaker certifying a bill as a money bill is final. But we have seen when Aadhaar was passed as a Aadhaar Act was passed as a money bill by the Parliament, this matter went to the court. One of the petitioners was Mr. Jairam Ramesh, who petitioned the Supreme Court, and right now this matter is before the court. The court will have to decide whether that certificate of the Speaker of the Lok Sabha certifying Aadhaar as a money bill, whether that was constitutional or not. Since judicial review is part of the basic structure, anything can be reviewed by the judiciary. Judicial review is not mentioned in the Constitution, but you can trace the concept of judicial review when it comes to Article 13 of the Constitution, when it comes to Article 32 of the Constitution, for example. Article 13, which says, Article 13, Clause 2, which says the state cannot make any law to delete a fundamental right, to abridge a fundamental right. And that is how we can trace the concept of judicial review. And Article 32, if your fundamental rights are violated, you can directly approach the Supreme Court. It is through these articles and also with Article 226 that we can trace the concept of judicial review. But judicial review as a term, as a concept, is not mentioned in the Constitution. How can constitutional bodies be established? You need to pass a constitutional amendment bill under Article 368 and create a constitutional body. To create a statutory body, you just need to pass a law, an ordinary law, by simple majority. For example, National Human Rights Commission is a statutory organization. That is it for today. See you again tomorrow. Do not forget to join me tomorrow, 7:30 p.m. And we have lots and lots of interesting and important things to discuss. And if you have liked the session, press the like button and let me know in the comment section. See you tomorrow, 7:30 p.m. Till then, have a great time. Stay safe. Good night.